Terra nullius is a Latin expression deriving from Roman law meaning nobody's land, which is used in international law to describe territory which has never been subject to the sovereignty of any state, or over which any prior sovereign has expressly or implicitly relinquished sovereignty. Sovereignty over territory which is terra nullius may be acquired through occupation, though in some cases doing so would violate an international law or treaty. Australia. Indigenous Australians had inhabited Australia for 50,000 years before European settlement, which commenced in 1788. Indigenous customs, rituals and laws were unwritten and their social and political organization was unknown or understood by Europeans as being analogous to their own institutions, and the British could not find recognized leaders with whom they could sign treaties. The first test of terra nullius in Australia occurred with the decision of R.V. Tommy, which indicated that the native inhabitants were only subject to English law where the incident concerned both natives and settlers. The rationale was that Aboriginal tribal groups already operated under their own legal systems. This position was further reinforced by the decisions of R.V. Boatman or Jackass and Bullis and R.V. Ballard, prompted by Batman's treaty with Wurundjeri elders of the area around the future Melbourne. In August 1835, Governor Bourke of New South Wales indicated the significance of the doctrine of terra nullius by a proclamation that Batman's so-called treaty was null and void because Indigenous Australians could not sell or assign land, nor could an individual person or group acquire it, other than through distribution by the Crown. The first decision of the New South Wales Supreme Court to make explicit use of the term terra nullius was R.V. Merrill and Bummery. Terra nullius was not endorsed by the Judicial Committee of the Privy Council until the decision of Cooper v. Stewart in 1889. Some 53 years later, in 1971, in the controversial case of Miliefam v. Nabalco Pty Limited, popularly known as the Gove Land Rights case, Justice Richard Blackburn ruled that Australia had been considered desert and uncultivated before European settlement, and therefore, by the law that applied at the time, open to be claimed by right of occupancy, and that there was no such thing as native title in Australian law. The concept of terra nullius was not considered in this case, however. Court cases in 1977, 1979, and 1982 brought by or on behalf of Aboriginal activists, challenged Australian sovereignty on the grounds that terra nullius had been improperly applied. Therefore, Aboriginal sovereignty should still be regarded as being intact. The courts rejected these cases, but the Australian High Court left the door open for a reassessment of whether the continent should be considered settled or conquered. Later, on 1 February 2014, the traditional owners of land on Badu Island received freehold title to 10,000 hectares in an act of the Queensland government. In 1982, Eddie Mabo and 4 other Torres Strait Islanders from Mare started legal proceedings to establish their traditional land ownership. This led to Mabo v. Queensland. In 1992, after 10 years of hearings before the Queensland Supreme Court and the High Court of Australia, the latter court found that the Mare people had owned their land prior to annexation by Queensland. The ruling thus had far-reaching significance for the land claims of both Torres Strait Islanders and other Indigenous Australians. The controversy over Australian land ownership has erupted into the so-called history wars. Historian Michael Connor, in his critique of the legal fiction, has claimed that the concept of terra nullius was a straw man developed in the late 20th century. By the time of Mabo in 1992, terra nullius was the only explanation for the British settlement of Australia. Historians, more interested in politics than archives, misled the legal profession into believing that a phrase no one had heard of a few years before was the very basis of our statehood, and Reynolds' version of our history, especially the law of the land, underpinned the Mabo judge's decision-making. There is some controversy as to the meaning of the term. For example, it is asserted that, rather than implying mere emptiness, terra nullius can be interpreted as an absence of civilized society. The English common law of the time allowed for the legal settlement of uninhabited or barbarous country. Other claims of terra nullius: Scotland, the Netherlands, and Denmark-Norway all claimed sovereignty over the region in the 17th century, but none permanently occupied the islands. Each visited Svalbard only during the summer for whaling, with the first two sending a few wintering parties in the 1620s and 1630s. Greenland. Norway occupied and claimed parts of eastern Greenland in the 1920s, claiming that it constituted terra nullius. The matter was decided by the Permanent Court of International Justice against Norway. Antarctica. Another example of a terra nullius was Antarctica, which was not sighted by humans until the second voyage of James Cook in 1773–74. Several countries made claims to parts of the continent in the first half of the 20th century, while other areas remain unclaimed. Scarborough Shoal. The Philippines and the People's Republic of China both claim the Scarborough Shoal or Panatag Shoal or Huangyuan Island, nearest to the island of Luzon, located in the South China Sea. The Philippines claims it under the principles of terra nullius and EEZ. China's claim refers to its discovery in the 13th century by Chinese fishermen. The former nationalist government on the Chinese mainland had also claimed this territory after the founding of the Republic of China in 1911. New Zealand. In 1840, Lieutenant William Hobson, following instructions of the British government, pronounced the southern island of New Zealand to be uninhabited by civilized peoples, which qualified the land to be terra nullius, and therefore fit for the Crown's political occupation. Hobson's decision was also influenced by a small party of French settlers heading towards Arkaroa on Banks Peninsula to settle in 1840. Canada. Joseph Truch, the first Lieutenant Governor of British Columbia, insisted that First Nations had never owned land, and thus could safely be ignored. It is for this reason that most of British Columbia remains unceded land. In Guerin v. The Queen, a Supreme Court of Canada decision on Aboriginal rights, the court stated that the government has a fiduciary duty toward the First Nations of Canada and established Aboriginal title to be a sui generis right. Since there has been a more complicated debate and a general narrowing of the definition of fiduciary duty. Guano Islands. The Guano Islands Act of 18 August 1856 enabled citizens of the U.S. to take possession of islands containing guano deposits. The islands can be located anywhere, so long as they are not occupied and not within the jurisdiction of other governments. It also empowers the President of the United States to use the military to protect such interests, and establishes the criminal jurisdiction of the United States. Pinnacle Islands. A disputed archipelago in the East China Sea, the uninhabited Senkaku Islands, are claimed by Japan to have become part of its territory as terra nullius in January 1895, following the First Sino-Japanese War. However, this interpretation is not accepted by the People's Republic of China and the Republic of China, both of whom claim sovereignty over the islands. Burkina Faso and Niger. A narrow strip of land adjacent to two territorial markers along the Burkina Faso-Niger border was claimed by neither country, until the International Court of Justice settled a more extensive territorial dispute in 2013. The former terra nullius was awarded to Niger. Clipperton Island. The sovereignty of Clipperton Island was settled by arbitration between France and Mexico. King Victor Emmanuel III of Italy rendered a decision in 1931 that the sovereignty of Clipperton Island belongs to France from the date of November 17, 1858, the Mexican claim was rejected for lack of proof of prior Spanish discovery and, in any event, no effective occupation by Mexico before 1858, when the island was therefore territorium nullius, and the French occupation then was sufficient and legally continuing, current terra nullius. Bertawil between Egypt and Sudan is the 2,060 square kilometers landlocked territory of Bertawil, which was created by a discrepancy between borders drawn in 1899 and 1902. One border placed Bertawil under Sudan's control and the Halib Triangle under Egypt's, the other border did the reverse. Both countries assert the border that lets them claim Halib, which is significantly larger and next to the Red Sea, with the side effect that Bertawil is unclaimed by either nation. The area is, however, under the de facto control of Egypt, although it is not shown on official Egyptian maps. Bertawil has no settled population. In June 2014, Jeremiah Heaton planted a flag in Bertawil to claim the region as a new sovereign state, the Kingdom of North Sudan, and subsequently announced the establishment of self-styled embassies elsewhere in the world. No governmental entity has recognized this claim. Dixon Entrance. At the Dixon Entrance, the maritime border between Alaska and British Columbia is disputed by the U.S. and Canada. A line known as the AB line was defined in a 1903 arbitration decision on the Alaska-Canada boundary. The court specified the initial boundary point at the northern end of Dixon Entrance and also designated point B, 72 nanometer to the east. Canada's position is that A and B are part of the arbitrated boundary delimitation, thus rendering nearly all of Dixon Entrance as internal waters. The U.S. does not recognize the AB line as an official boundary, instead regarding it as allocating sovereignty over the land masses within the Dixon Entrance, with Canada's land south of the line. The U.S. regards the waters as subject to international marine law, and in 1977 it defined an equidistant territorial line that is mainly to the south of the AB line, but not entirely. North of Dundas Island, the equidistance line swings north of the AB line. The intersecting lines create four separate water areas with differing claim status. The two areas south of the AB line are claimed by both countries. The other two water areas are north of the AB line and are not claimed by either country. The two unclaimed areas are about 72 square kilometers and 1.4 square kilometers in size. Land portions along the Danube River as a consequence of the border dispute between Croatia and Serbia. There are some areas along the western bank of the Danube River that are unclaimed by either country. In 2015, Czech activist V. Jedlicka unilaterally declared a micronation he named Free Republic of Liberland, espousing libertarian ideals and claiming the largest of the disputed pockets on the right bank of the Danube. Shortly after, the Kingdom of Enclave was declared, eventually claiming the second largest pocket as their territory, followed by the Principality of Ongel, which claimed the remaining pockets. The Croatian Ministry of Foreign and European Affairs has rejected these claims, stating that the differing border claims between Serbia and Croatia do not involve terra nullius, and are not subject to occupation by a third party. Land strip at the Croatia-Slovenia border. Brezovica pri Metlici is a village located in the southeastern part of Slovenia, about 50 kilometers air distance from Zagreb, Croatia. Brezovica Zumbaraca is a Croatian exclave that is surrounded by the Slovenian village. It is confirmed by both Croatian and Slovenian cadastre maps, although boundary lines slightly differ. Croatia has a second exclave within 400 meters of Brezovica Zumbaraca. This exclave would normally be an enclave also, except that neither Slovenia nor Croatia claims one parcel of land that adjoins the exclave. If Slovenia were to claim the parcel, Croatia's exclave would become an enclave as well. As it is, the exclave is bordered by Slovenia and terra nullius. In April 2015, a group of tourists from Poland visited Brezovica to declare unclaimed land strip as sovereign state, the Kingdom of Enclava. On 21 May 2015, the Slovenian Foreign Ministry said that the territory was Slovenian and that the determination of land borders between Slovenia and Croatia should take place in the Court of Arbitration. The founders of Enclava ceased their claim and moved to the second of the largest unclaimed land portions along the Danube River near the Croatian village of Batina and Liberland, unclaimed areas in Antarctica. While several countries have made claims to parts of Antarctica, most of Marie Byrd land has not been claimed by any sovereign nation. Signatories to the Antarctic Treaty of 1959 agreed not to make such claims, except the Soviet Union and the United States, who reserved the right to make a claim. The Norwegian claim to Queen Maud Land left its southern boundary undefined, so the southern part of that segment of Antarctica may also be unclaimed. International Sea. Under the United Nations Convention on the Law of the Sea of 1982, the international waters and international seabed are treated under the common heritage of mankind principle by the signatories of the convention. Celestial bodies. According to the Outer Space Treaty of 1967, outer space, including the Moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. For the signatories of the treaty, celestial bodies are treated, de jure, under the common heritage of mankind principle. However, this has not stopped many people from exploiting the fact that these claims only account for countries, not companies and individuals. No known micronations, however, have been claimed on other celestial bodies, with the exception of the Arican Empire. Limits of national jurisdiction and sovereignty. They confirm the full national jurisdiction over the coastal waters and over the continental shelf underground. There are limitations that allow foreign vessels the right of passage and for foreign states to lay pipelines and cables in the territorial waters, exclusive economic zone and continental shelf surface. Exploitation of marine life and mineral resources in these areas is a reserved right of the coastal state. Exploitation of mineral resources in the extended continental shelf is a reserved right of the coastal state, but it must pay tax on these activities to the International Seabed Authority. The archipelagic waters are covered by a special hybrid regime with rules regarding territorial and internal waters, on vessels, spacecraft and structures in places with international jurisdiction or terra nullius. The general rule is that the operator state of the vessel is responsible for it and regulates laws there. Additionally, the crew are subject to the laws of the state of their citizenship. Earth orbital slots are the only type of extraterrestrial real estate recognized by law and are allocated by the International Telecommunication Union. There are some undefined limits for the application of jurisdiction and sovereignty. The boundary between outer space and airspace is not defined. In common parlance, the Kármán line is generally recognized as the boundary between airspace and outer space, but this definition is not explicitly recognized in any treaty. UNCLOS Commission is defining the limits of the extended continental shelf. UNCLOS is inconclusive about the status of airspace over the contiguous zone. There is no defined bottom underground limit for jurisdiction and sovereignty, because in practice there are no cases where it is relevant and the current technology level does not allow the reaching of depths where conflicting claims could be made. The current entities that exercise jurisdiction and sovereignty rights are the 193 United Nations member states, Holy See and Palestine, the United Nations Observer States, Cook Islands and Niue, associated with and represented in foreign affairs by New Zealand, the 17 non-self-governing territories with recognized right for self-determination by the United Nations, the 10 states with limited recognition.